A warm welcome to anyone that hasn't been to one of our webinars before, and to those familiar names that have joined us today. I really appreciate you all taking the time out of your busy schedule. So just to introduce you to us, so I'm Laura Wright and we'll be leading the webinar today, and we also have the fabulous Grace Jeremy, our HR coordinator, who will be making sure today's webinar runs smoothly. So just a bit about myself. I'm one of the HR consultants at Kingswood Group. I support businesses of different sizes from a variety of different industries with their HR needs. I wasn't always in HR. First had a career in leadership and management before moving to a pure HR role in 2018. And before joining Kingswood, I worked mainly in-house HR roles with some large multi-site organisations. At Kingswood Group, most of the businesses I support are SMEs, and they are all fantastic and a pleasure to work with. And when I'm not doing all things HR, I spend time with my 4-year-old daughter, who has just started school this month and is very good at keeping me busy. Great, so today we are using a GoToWebinar to host this webinar today. So for those of you who haven't used the platform before, you're all muted, so we can't see you. Any questions you have for the panel, just as we go through the session, put in the question box, and we'll try to answer as many as we can at intervals or at the end of the webinar. Depending on whether you're using the web version or desktop version, you can navigate to the relevant part of the app to ask these questions. Great, so again, before we start the webinar, just a little bit about us. We're a HR consultancy with a growing team of experienced consultants. At Kingswood Group, our focus is on delivering HR solutions that are generally tailored to your business. We understand no two organisations are the same, whether you're a small or medium-sized enterprise looking to scale up, or a larger company aiming to refine and improve existing HR processes. Our services are designed to be flexible and comprehensive. We support you in enhancing operational efficiency, staying compliant with employment law regulations, and ultimately freeing up your time so you can focus on what matters most, growing your business. So if you need a new employee handbook or employee contracts, or someone to chair a disciplinary or guide you through a redundancy consultation, we are here to help you. We work on a retained basis or pay-as-you-go or project basis. And as mentioned, our services are bespoke. So if you are considering retainer, we understand that one size doesn't fit all, and can tailor these solutions to meet the needs of your business. I'm based in Essex, which is great for those clients as I often go out to see them face to face. However, I have also travelled to Oxford with Grace, actually, so it doesn't really matter where you are. We don't operate like a call centre, so you always get to know the team, and if you want a dedicated consultant, you can have one. We offer a multitude of other services that go hand in hand, like training, profiling and HR software. And we go into more detail about these services at the end of the webinar, if you're happy to stay on with us. Okay, so just moving on to the agenda for today's webinar. At the end of the session, hopefully you'll have a clearer understanding of how to carry out workplace investigations fairly, confidently and in line with UK employment law. You'll be able to plan and document each stage of the process, protect your organisation while supporting those involved, know when to seek professional external help, and ultimately you can seek external support from us at Kingswood at any stage of the process, and we gladly guide you. However, it's always easier when we're involved at the start. We talk about that in some of the other slides. The webinar is scheduled for 1 hour. We may be finished before, depending on how many questions we get ultimately. But do ask questions as we go. Enjoy it more if it's interactive. Grace will stop me if appropriate to answer the questions, as I can't see them in front of me at the moment. Okay, so the first part of this webinar, we're just going to talk about understanding when and why to investigate. So we cover key triggers for workplace investigations, the difference between fact-finding and decision-making, and common mistakes to avoid early in the process. So before we start, is anyone currently in the middle of managing an investigation at the moment? If you are happy to share in the chat, then I'd really like to hear from you. So please do, and hopefully this webinar will help you in some way. I'll just carry on talking, but again, please feel free to pop anything in the chat if you'd like to. So when might you need to start an investigation? There are various different scenarios, as I'm sure you all imagine. It could be related to complaints or grievances. So when an employee raises a formal grievance like bullying, harassment, discrimination or unfair treatment. It could be allegations of misconduct. So you could have a breach of company policies or code of conduct. So it could be a breach of health and safety, for example. Inappropriate behaviour, breach of confidentiality, gross misconduct. Other triggers could be performance and attendance issues, so persistent poor performance, pattern of unexplained unauthorised absences, regulatory or legal compliance concerns, so things like breach of sector-specific regulations and data protection breaches. Financial business irregularities like fraud, theft, financial mismanagement, or conflicts of interest. And there are also things like external triggers, so customer complaints raising serious allegations. If anyone can think of any more, then please do drop it in the chat. I'd be interested to hear. Okay, I'm going to move on to fact finding versus decision making. So it's important to understand the difference between fact finding and decision making as to not flaw the investigation process. So key difference in practice, fact finding would be what happened, so it's the role of the investigator, and decision making would be what should we do about it, and that's the role of the disciplinary chair. So it's important to make sure that those are separated and not confused. So keeping these stages separate helps ensure fairness, avoids bias, and is in line with the Acas Code of Practice, which tribunals take into account in unfair dismissal claims. So it's really important to bear this in mind. Your fact-finding focus should be collecting information and not judging. And if you're a decision maker, the focus would be weighing evidence and applying company policy fairly. The tasks involved in fact-finding will typically be interviewing witnesses, reviewing evidence, and while remaining impartial, which is key. The investigation outcome report will set out the facts, but will not recommend sanctions. That will be the decision maker. And the task involved in decision making as a disciplinary chair is reviewing the report, assessing the balance of probabilities and mitigating factors, and ultimately an outcome and a sanction. So hopefully that makes it clear the role of an investigator that's purely fact-finding. Okay. So moving on, common mistakes in early employment investigations. So in the early stages of an employment investigation, it's critical because mistakes made at the start can undermine the entire process. And this is why I mentioned earlier, it's preferred that if you are considering external support, you get involved at the point of the allegation being raised. The earlier the better. So some common mistakes, not acting promptly. So any delay in starting an investigation can make evidence go stale. You probably relate to this. So what you did maybe 2 days ago, you're not going to remember as much as you did if it was 2 hours ago. Memories fade, documents disappear. Acas guidance stresses investigations must begin without reasonable delay. And so other mistakes, failing to define the allegations clearly. Vague or shifting allegations confuse everyone, and the employee may not know exactly what they are accused of, which risks an unfair process. Another one, using the wrong investigator, so appointing someone who has a conflict of interest, for example, a manager that's directly involved in the incident, or an investigator should always be impartial and not the eventual decision maker. Not preserving the evidence, so failing to secure emails, CCTV, HR records or other documents at the start. Risk that key evidence is deleted or tampered with. Poor communication with the employees, they're not telling the employee the nature of the concern early enough, or failing to explain the process and their rights. For example, right to be accompanied later on. Breaching confidentiality, so sharing allegations too widely. Mixing investigation disciplinary, as we said before, it's really important that you're clear that as an investigator, you're fact-finding only. Not recording early steps properly, failing to consider support needs or reasonable adjustments. So it's important you should do things like offer wellbeing to support to the complainant, accused or witnesses, and consider things like language barriers or disability needs. Not offering an interpreter if necessary could flaw the process, but if this so not offering an interpreter, it won't necessarily flaw the process, but it could if the subject doesn't understand. So it's important if there are any language barriers, you establish them early on and find out if an interpreter is needed. So best practice, start quickly, define the allegations clearly, appoint an impartial investigator, preserve the evidence, maintain confidentiality and consider support needs. So any questions? We'll move on. No questions, Grace? All good? Okay. So
yeah, just keeping an eye on the chat, but all good.
Oh, good, thank you. Okay, next part, we're going to move on to getting the legal and ethical framework right. So in this section, we're going to talk about your legal responsibilities under UK employment law, how to protect confidentiality and avoid bias. So legal responsibilities and best practice. There are a number of legal responsibilities and best practice requirements when managing investigations, and that stem from employment law, case law, and the Acas Code of Practice on disciplinary and grievance procedures. So procedural fairness, investigations must be fair, impartial and reasonable, and employees have the right to know the allegations and respond, and employees must avoid a predetermined outcome. Acas, so while not legally binding, employment tribunals take compliance with Acas into account, so do follow the Acas Code. A failure to follow the Acas Code can result in compensation being uplifted by up to 25%, so depending on what it is. Key duties under the code, so act promptly and without unreasonable delay, carry out thorough and proportionate investigations before taking action, allow the employee to be accompanied at disciplinary hearings. This doesn't apply to investigations. Provide clear and written outcomes and reasons. Again, this applies to the disciplinary process. Employment Rights Act 1996, employees have the right not to be unfairly dismissed after 2 years service. Unfair dismissal can result from conducting an unfair investigation process, so it's important that this gets that you get this right. The Employment Rights Bill has proposed that the right not to be unfairly dismissed will become a day one protection. We don't know too much more at the moment, but it is a proposal and it is something that could happen in the future. Other things to consider, so the Equality Act, investigations must be handled without discrimination, harassment or victimisation. So make sure you've got your EDI policy and follow that. Investigators must take care not to allow unconscious bias or discriminatory treatment, and special care to be taken if the complaint involves the complaint involves protected characteristics like race, sex, disability. Data protection, so under UK GDPR and Data Protection Act 2018, investigation records are personal data and must be processed lawfully. So things like witness statements, interview notes. Employees should be told how their data will be used, stored and shared. So just a bit of a recap really. So practical steps for compliance to make sure you adhere to your legal responsibilities. Appoint an impartial investigator. So it doesn't have to be somebody external, but somebody impartial within your organisation. Keep a clear paper trail of the investigation process. Apply the organisation's disciplinary and grievance procedures consistently. Follow the Acas Code of Practice. Take steps to ensure you abide by UK GDPR and data protection, and offer support to all parties. So this could be things like if you've got an EAP, make sure you offer that support to anyone involved. Okay. So I thought it'd be worthwhile just covering suspension as well, because this can sometimes come, especially like in a gross misconduct allegation. So suspension should not be a default action, but a carefully considered measure of last resort. So it is a neutral act and not a punishment, and only to be used where necessary. If the subject needs removing from their immediate workplace or role for whatever reason, consider alternatives first. Alternative to suspension, they're not going to apply to everyone or every scenario, but these are some possible alternatives. Temporary redeployment to another role or location, adjusting duties to remove access to sensitive information, people or property equipment. For example, a forklift truck driver following a health and safety incident, you could adjust their duties to remove access to it. Restrict IT system access, or allow working from home, again, if suitable, if it allows within your business. If the employee is off sick or otherwise absent when considering suspension, you maybe just think about whether you need to suspend, otherwise you would just end up paying them in full when they could be on statutory sick pay, for example. It is a measure of last resort, so if suspension is to remove them from the workplace, sickness absence will already be doing this. However, there are some circumstances where it may still be necessary to suspend if you are aware the employee has contact with colleagues throughout their absence and there is a serious alleged behaviour. You will need to assess whether this unrestricted contact could interfere with the investigation. Ultimately, if you're in doubt, just seek advice and we can talk through the scenarios. Unfortunately, there isn't always a one size fits all, and so we do have to consider lots of different aspects when before considering suspension. The process for suspension, so you need to make sure you document why suspension is necessary and why alternatives were not appropriate. Explain clearly that suspension is a neutral act. It can sometimes feel like it's disciplinary, but it is a neutral act to protect the individual. Provide the expected duration, though it may change. Confirm pay and benefits will continue, and send a suspension letter outlining the reason, duration, obligations, for example, confidentiality, and that they need to be available for meetings. Limit who is told and how it is communicated internally. This is to avoid stigma or reputational harm. It's a good idea to agree with the employee that what you're going to tell their colleagues, because you know that where somebody's taken out of the business, everyone's going to ask, where are they? So it's good to agree with that employee what you're going to say. It could just be you're saying that they're going to take a leave of absence, and that should be the end of it. But I think this is always a good conversation to have. So during suspension, full pay and benefits apply. Regular reviews, you need to keep the suspension under review to ensure it remains necessary and proportionate. It shouldn't be a lengthy suspension, it should be as short as possible. Support for the employee, signpost to HR or employee assistance programs, and maintain contact. So check in with the suspended employee regularly, so that they're not left isolated or uninformed. I'd say like once or twice a week is sufficient. The risks of mishandling suspension. So if we're not going to follow the process, you could leave yourself open to things like constructive dismissal claims, if it appears disproportionate, discrimination claims, if suspension's not consistent or it's been unfairly applied, reputational harm to the employee if confidentiality is breached, and tribunal criticism. So if suspension is used automatically without considering alternatives, this isn't looked upon very kindly by the tribunal. Great, I'm just going to move on then now to confidentiality. So confidentiality is about fairness, accuracy, and protecting all individuals involved. It's critical to maintain confidentiality during investigations for several reasons. It protects the integrity of the investigation, ultimately. So if too much information is shared, witnesses may align their stories, evidence may be tampered with, or individuals may be influenced by what they hear. And confidentiality helps ensure that findings are based on honest and independent accounts. It safeguards employee trust. Employees are more likely to come forward with concerns or cooperate with investigators if they know their information will be handled discreetly. Trust is essential for uncovering the truth, ultimately. It protects reputation. So allegations in the workplace investigations may not always be substantiated. So maintaining confidentiality prevents unfair damage to the reputations of the complainant, the respondent, and the witnesses. It reduces retaliation risks. So confidential handling of complaints helps protect employees from retaliation, harassment, or workplace hostility, which can arise if details become widely known. And it ensures compliance with laws and policies. So many employment laws, such as those related to harassment or discrimination, require that complaints be handled confidentially. Employees can face legal consequences if they mishandle sensitive information. So to protect confidentiality and avoid bias, some things we recommend you do. So limit information sharing and share investigation details only with those who need to know. So the investigator, HR, relevant managers, if you're suspending, for example. And avoid discussing the case informally with colleagues. That's a big no. Secure records, so secure and store investigation notes, witness statements, evidence in restricted access systems, so password protect or encrypt where possible, and keep paper files, if you have to have paper files, locked in cabinets. Data protection compliance, so follow UK GDPR and data protection, have a lawful basis for processing personal data and inform employees how that information will be used. I think we talked about this earlier, but just a reminder, and do not retain records longer than necessary. And confidentiality reminders, so at the start of each interview, remind participants of their duty to maintain confidentiality. Employees can still seek advice from union representatives or legal advisor, but just remind them at the start of each interview and at the end, to be honest, because they do forget, and put it in letters that anything that is discussed in an investigation meeting is confidential. Okay, great. So we can move on to the next section if there's no questions. Okay, great. So in this next section, we're going to talk about planning and preparation for the investigation. So we'll talk about choosing the right investigator and setting clear boundaries, communicating clearly with all parties involved, and managing adjustments and expectations. Okay, so roles and responsibilities. It's probably worthwhile just running through these. I'm sure you know them already, but let's just talk about the various roles in an employment investigation. It's important these responsibilities are clearly understood from the start of the process. So the employer has a duty of care to ensure the investigations are fair, impartial and timely. They need to follow company policies and protect confidentiality and privacy of all parties involved, and provide access to HR support if needed. We've also got the investigating officer. So the investigating officer should be focused on fact finding only, as we talked about earlier, gathering evidence, interviewing witnesses, reviewing documents. Impartial, they must be independent of the incident, not involved in the alleged conduct. They need to be able to produce an investigation report that sets out findings but does not usually recommend sanctions. So they would just need to be able to report on the investigation and the facts. Timeliness. This is a really important one as well about the investigator. So they need to be able to progress the investigation without unnecessary delays. So not somebody that's about to go on annual leave. We've also got HR. So HR would not usually be a decision maker. They would guide managers on the process, policy and fairness, but wouldn't be involved in determining the outcome. So HR can sometimes be involved in the investigation process, but would just advise on policy when it comes to the disciplinary. HR will make sure that accurate records of interviews are kept, and probably provide you things like templates for recording these. So we've also got witnesses as well. So witnesses should be providing honest accounts and evidence when asked, should be keeping everything confidential. And who else have we got on there? Note taker. So note takers are also really important. So make sure that they are experienced and able to take summary notes. Sometimes the note taker can be HR or another competent person, but make sure that they have done it before if they haven't already. It's something you need to practice with. You need to make sure you can keep up to make sure you capture as much information as possible. Okay. Any questions on that?
Nothing's come through.
Okay. Okay, so appointing the investigating officer. So as discussed, as we've talked about quite a lot, the investigating officer's role is to gather evidence, interview witnesses and review the documents. They must be independent, not involved in the alleged conduct, and equally do not appoint somebody that is a friend of the subject or complainant. They should have no personal interest or bias, whether actual or perceived, as this could flaw the findings. So avoid somebody that has already expressed views or opinions about the case. The investigating officer should be sufficiently senior to command respect and handle sensitive matters. They should not be the same person who will ultimately decide on disciplinary action. So consider saving more senior managers for disciplinary or appeal. They must be competent in order to produce a comprehensive investigation report that sets out findings. So if they haven't led an investigation before, they should seek guidance from HR to help with planning and producing compliant documentation. As a minimum, they need to have the skills to interview witnesses and analyse evidence fairly. They also need awareness of Acas Code of Practice and relevant employment law. They must be able to progress the investigation without unnecessary delay. So, as I said on the previous slide, if they are set to go on holiday a few days after starting investigation, it's not ideal to appoint them as the investigating officer. Delays undermine fairness ultimately, so consider who else could do it in their absence. They must be trusted to maintain confidentiality throughout the process. So if you haven't got anyone in your organisation that can fulfil all these traits, you should probably seek external support. So at Kingswood Group, our HR consultants are all qualified to independently carry out investigations. So if this is something that you need, then please do contact us, and we will support you if we can. Great.
Sorry, Laura. I've just had a question come through about note taking. So someone's just asked, is it better to have handwritten notes or is it better to record a meeting?
Okay, so yeah, so you've got a few different options here. So you could handwrite the notes, you could type them, or you could record the meeting. So if you are going to audio record the meeting, you'd need consent from all parties in the first instance. So if you don't have that, the options are going to be to type or handwrite. If you handwrite the notes, they need to be signed and kept because they do form part of the evidence. Don't write them and then type them up and then discard the original written notes. They need both Both the handwritten and the typed notes need to be kept and both signed. If you can type as they talk, that's probably the best solution to that. So it doesn't really matter as long as the notes are complete, accurate, and capture everything that's discussed. So ultimately, you have somebody that can keep up with the notes or record it and get the consent. There's not really a one answer, really. It just really does depend on the scenario, but hopefully that helps, gives a few pros and cons for each.
Yeah. Thank you.
Thank you. Okay, great. So, So communication to manage expectations. At the start of the process, you need to clarify the purpose. Explain that the investigation is fact-finding and not a disciplinary hearing, because that can sometimes be confused. Outline the process, so who will be investigating, the steps involved, likely timescales, and what will happen with findings. And set realistic timelines. So investigations can take time. It's not usually something that's done in a couple of days. It can go on for a couple of weeks. Communicate a clear expected duration, but caveat that it may change depending on evidence, witness availability. Explain confidentiality and stress that information should not be shared outside of the process, but avoid giving absolute confidentiality, since information may need to be disclosed in certain circumstances. How information is handled during an employment investigation can make a big difference to trust, fairness, and reducing risk. So during the process, keep parties updated, and silence can create anxiety and mistrust. So provide regular updates, even if only to say that the investigation is still ongoing, and be clear about the roles. Again, the investigating officer gathers facts only. With the employee under investigation, provide written notice to attend an investigation meeting. It's not necessary to provide written notice, but it is good practice. And there may be situations where it's not appropriate, for example, if you think the subject is likely to influence witnesses. Reassure witnesses they are protected and that retaliation will not be tolerated. And after the investigation is concluded, explain the next steps. Let all parties know how and when they'll be informed of the outcome. Communicate appropriately. The person under investigation should be told whether it's proceeding to disciplinary, and complainant should be told whether their complaint was upheld. Remind all parties that confidentiality remains even after the investigation has concluded. And it's a good idea as well, if you do have an employee assistance programme, to signpost employees affected to support like this.
I just have a quick question, Laura.
Yes.
Just regarding confidentiality, if someone, for instance, didn't adhere to that, what could you do, or is there anything that can be done?
If someone breached confidentiality, ultimately that's a misconduct in itself. So it could be that another investigation starts up for that. It really depends. Really depends on what how it's happened, what's happened. It's probably not a very good answer, actually, is it? Yeah, no, that's fine. But yeah, it is a misconduct ultimately. If you're breaching confidentiality, it's probably in your disciplinary policy somewhere that would be a misconduct allegation. So it could result in action against themselves. So it's important to remind. It could flaw the investigation if they breach confidentiality. So just the best thing you can just do is remind. They can't be told it too many times.
Mm-hmm. Okay, brilliant. Thank you.
Thank you. Great, so we'll move on to the next section. Okay, so conducting effective investigations we're going to talk about next. So this will be interviewing witnesses fairly and respectfully, gathering, storing and documenting evidence, and handling conflict, difficult conversations or emotional responses. So fairness is critical to meet ACAS standards, and poorly handled witness interviews can undermine the whole process. So some key considerations to ensure these are managed fairly and respectfully are preparation. So plan questions in advance, focus on facts, I can't even say the word, chronology and observations and not opinions. Review policies and allegations, ensure you understand the context before speaking to witnesses. Choose a suitable location, so a private, neutral, free from interruptions to protect confidentiality. So don't choose a room where the walls are thin and other people can hear your conversation. And notify witnesses in advance, so give reasonable notice if possible, and explain the purpose of the interview. Again, as we discussed previously, there may be circumstances that advance notice is not possible. And consider the order in which you interview witnesses and the subject. So usually in an investigation, you'd interview the subject last and interview the witnesses first. Again, it may change depending on what the allegations are, but this is usually how you would handle it. Transparency and role clarity. So explain the investigator's role, fact finding, not deciding outcomes, and outline the process, how their statement will be used, who may see it, and potential follow-up, and set boundaries. Make clear that gossip, speculation, or relevant issues won't be used in the outcome. Confidentiality again, so stress discretion, and witnesses must not discuss the case with colleagues. Fairness, impartiality, so ask open questions, encourage witnesses to describe what they saw, heard, rather than leading them. So avoid asking questions that can be only answered with a yes or no, and avoid assumptions, so don't phrase questions in a way that suggests a conclusion. So for example, you'd say like, so when they shouted at you, instead say things like, what was said and how was it said? Give time, so allow witnesses to think, check notes and respond fully, and record accurately. Ensure notes reflect the witness's words and not the investigator's interpretation. Witness support, so allow accompaniment if appropriate. So while it's not a statutory right, certain circumstances you may permit a companion, usually a colleague, to attend if the matter is particularly sensitive. And if allegations involve things like harassment, bullying or discrimination, conduct the interview with particular care and empathy, and offer breaks, so especially if the matter is stressful or emotional, and consider adjustments such as an interpreter if needed. So for documentation, keep clear records, produce a written statement of notes of the interview. As we talked about earlier, it's useful to have a note taker. Alternatively, you could ask for consent to record the meeting. Seek agreement from the witness to review and confirm the accuracy of their statement. So get them to sign the notes. If a witness won't sign or cooperate, record this fact objectively. It might be that there's a reason. I mean, sometimes as well, if you do need to make adjustments or amendments to the notes, keep the original and then just put a note on the notes and their initials to say what they wanted it to change to, so you can see what the original said and what their version of the notes were. Handling difficult situations, so reluctant witnesses, reassure them of the importance of their evidence and protection against retaliation. Record all versions without making judgments. Assessing credibility is for the disciplinary decision maker and not the investigator. I would only use, I wouldn't recommend anonymous evidence. I'd only use with caution and avoid if possible. It does carry less weight, but it may be necessary in cases where witnesses fear reprisal. So closing the interview, check for completeness, ask if there's anything else that the witness or subject wants to add, and explain the next steps. Tell them that they may be contacted again and reiterate confidentiality and thank them for their cooperation. I have added a note actually on that slide just to say don't be afraid to go back to a witness or a subject to ask more questions. sometimes the direction of the investigation will change. There's no rule to say that you can only have one investigation meeting with each witness or subject. So if there's something you've missed off, don't worry, just invite them back in and ask those questions. There's no need to leave a gap. You can go back and ask. Okay. So gathering, storing and documenting evidence. So how you gather, store and document evidence in an employment investigation can make or break the credibility of the process. So be thorough and balanced, collecting evidence both for and against the allegations if available to avoid claims of bias. Types of evidence, so things like witness statements, interview notes, emails, documents, messages, policies, CCTV, system logs, and physical items where applicable. Ensure evidence gathering and storage complies with GDPR and avoid covert monitoring unless absolutely justified, proportionate and in line with the employer's policies. Restrict access to only those with genuine need to know, for example, the investigator, HR, and use encrypted drives or secure HR systems for digital files, lock paper records in cabinets, and follow your organisation's data retention policy. Have witnesses review and sign their statements or interview notes, as we've discussed before, to confirm accuracy and keep the format consistent. Record when, how, and from whom evidence was obtained, especially for sensitive or digital evidence, and document in the outcome report why certain evidence was not available or not used. Okay. And handling conflict and difficult conversations. So unfortunately, not all investigations will run smoothly. Tensions are high, especially with those that have been accused of wrongdoing, and there are also times when you may experience those being investigated or witnesses become emotional. Investigations require both professionalism and sensitivity. Conflict cannot always be avoided, but how it is managed ensures the investigation remains fair. So some things you can do: prepare carefully, review the facts and evidence and anticipate potential reactions, plan the questions so they are open and not leading. Set the right environment, choose a confidential setting and establish ground rules, so no interruptions, for example, switch off phones, remind confidentiality. Communicate professionally using a calm tone and avoid bias, and focus on the facts and behaviours. Rephrase any emotionally charged language into neutral terms. Listen actively and allow each person to share their views fully. Acknowledge emotions without agreeing or disagreeing. And stay calm to manage strong emotions like someone raising their voice or becoming upset. If this happens, pause the conversation, and if it escalates, then resume when participants can engage respectfully. Remind parties of expectations when rejoining. Keep the focus on the facts and guide the conversation back to specific incidents, dates and evidence, and document the meeting and include what was said, as well as any observations, breaks taken, and follow up the next steps. Okay. Okay, so we're coming towards the end of the webinar now. So this last section, we're going to talk about analysing the findings and writing the report. So we're going to talk about weighing evidence and reaching conclusions, what should and shouldn't be in your final report, and passing findings to the decision maker for next steps. So the investigating officer weighs evidence in the sense of evaluating consistency, corroboration and reliability when deciding whether allegations are substantiated or not. And the investigating officer does not recommend disciplinary action, but would refer any substantiated allegations to a disciplinary chair to review. When weighing evidence and concluding your investigation, apply the balance of probabilities and consider if it is more likely than not. For example, is it more likely than not that the alleged conduct occurred? Assess the evidence, review documentary evidence like messages and CCTV along with witness statements and notes. Again, circumstantial evidence such as patterns of behaviour, review previous warnings on file, for example. Weigh credibility versus reliability. Has the witness been honest? this is credible, so or is the evidence accurate and complete, reliable. Look for consistency within a person's account and between different sources. Check for corroboration, so evidence that supports another piece of evidence, and consider motive or bias. Does a witness have a reason to mislead the evidence? Look for any gaps in the evidence, such as missing records or incomplete timelines, and make sure these are recorded as well. Okay, so moving on to finalising the outcome report. If you haven't written one before, it can be quite a daunting task. You can use the Acas template, but at Kingswood we have actually got a more comprehensive investigation outcome template that can be used for complex or straightforward cases. And our template has a lot of useful guidance, so we're always on hand to talk you through if needed. And if you would like a copy, then please get in touch and we can talk about it. So use a structured analysis ultimately. So list findings for each allegation separately, if more than one, and try to use wording from your disciplinary policy if the allegations are listed here. Note any missing or conflicting evidence. Apply fairness, so avoid opinions and stick to the facts. Ensure both the complainant and respondent have had the opportunity to present evidence along with the witnesses. The investigation outcome report should outline the allegations, summarise the evidence reviewed and list in the appendices, and demonstrate clear, logical reasoning for conclusions, so there should be no opinion. For each allegation, conclude substantiated, more likely than not true, unsubstantiated, not enough evidence, or inconclusive, conflicting evidence, so you can't determine. Okay. So that comes to the end of the webinar. This is a bit of an opportunity if any of you have any questions, real life scenarios that you want to talk about and ask for some advice on. Just something that I will just share that does tend to happen quite commonly is when you start an investigation and the subject is notified, sometimes what can happen is they do get signed off sick. So whether this is genuine sickness or not, it does still pose a delay to the process and risks it coming flawed if there is no evidence to rely on other than witness statements. The first thing to check is whether the employee is unfit to work, for example, unfit to carry out their usual tasks, or if they're unfit to participate in employment-related meetings too. If their fit note doesn't expressly say unfit to attend meetings, I would discuss with the employee the possibility of proceeding with the investigation, as it is in the interest of their health as well. Any delays can exacerbate stress in some circumstances, so the employee may actually wish to continue with the process, so it's not hanging over them. So I would still ask the question. If they say no and their GP comes back with another fit note so they can't participate, then that's fine and we have to reassess the situation. But what we often do find is once the process is concluded, if the employee went off with stress, it is possible that this will relieve stress. Other things that you could do to get around this is you could offer the employee to participate remotely, or if face-to-face contact is not possible, there's the option of telephone or written submissions. If it's not possible to proceed with the participation, continue with interviewing witnesses and gathering other evidence to preserve validity of that until a point where the employee returns and you can conclude the process. Ultimately, investigations, they can grow legs, and what you think is a simple investigation doesn't always go to plan. And so if this does ever happen, please do just reach out, get some external advice for us and we can help you. Is there any other questions, Grace?
There is a question that's come through.
Oh, good.
Someone said, what if evidence of something is brought to you, but that person then says they want no further action taken?
Really does depend on what it is. I mean, employees have a duty of care to their employees. So if it is something serious, like breach of health and safety, for example, then the employer will need to investigate that. And so they can't really not do anything. So it really does depend on what it is. I'm happy to have a chat with that person after the call if they want to send me a message. What's the best way to get in contact, Grace? Actually, is there a...
Yeah, what I can do is I'll make a note, and then we can always drop an email. And
yeah, okay, yeah, we can do that then. I can always drop an email after, and if they want to ask something specific, it's difficult sometimes because some of these questions, there's lots of different ways it can go. So yeah, I'm happy to pick that up after this webinar today. Great. Was there any others?
Not come through, but I do have a question.
Okay.
So since talking about witnesses and if the subject gets signed off or anything before you can go through the process with them, if you have a witness who is, say, off on holiday for a week or 2 weeks, and I suppose it depends on what kind of information they give, but would you be able to speak to the subject before speaking to that witness, or would you advise to hold off, wait till the witness is back? And
again, it's one of those, it really does depend on what the allegation. There's a few different things you need to look at: what the allegations are, what are the witness's involvement. You can speak to the subject last. It may just that you may be sorry, start again. You can speak to the subject before the witness, but sometimes it could influence, and you'd be missing some information from the witnesses, and you may just have to go back to the subject again. So I think the best thing to do is plan out before you start, plan out who you're going to talk to, what's their involvement, and then you can work out whether it would have any influence over the course of the investigation on the order of who you speak to first. It depends. Yeah, it depends on the allegation and the scenario, really, and the people involved.
Okay. And then also just on anonymous witnesses, if I know you kind of spoke about that, but if there's anything, what does it mean? Is there any way you can sort of
you can use anonymous witness statements, but they just don't have as much weight as those with a name to them. So I would discourage them where possible. It may be that the witness is worried about retaliation of, for putting their name to something. So the best thing that you can do is just assure them that they are protected and that nothing will happen with them sharing honest accounts. Because ultimately it will dilute the evidence in a way that it doesn't carry as much weight with an anonymous statement as it does with somebody's name to it. In a tribunal, they would look at it and they would say, so who was this from? It could be made up for all they know. So it's important to put names to statements if possible.
There has been another question come through. So someone said, when the evidence is quite clear, can the right to respond just be at disciplinary hearing rather than during the investigation? So, for example, the conduct happened over all comms channels, so it's clear. So, I suppose that's what the evidence.
Yeah. So yes, that can happen. Yeah, I know what you mean. So in a situation where you're just going to be repeating questions in the investigation and disciplinary, then yes, you could go straight to the disciplinary, but it is best practice to give the subject the right to respond in an investigation. It could be that you just present them with some evidence and ask some briefer questions and then go into more detail in a disciplinary. But yeah, best practice is to give them the right to respond, but there are circumstances where you may choose not to. Again, happy to, if you've got a specific example and want to talk after this, then I'm more than happy to share some advice. And it's always good to get the full picture before I give you a definite answer. It's hard when we're sort of summarising the cases.
Joanna, she said thank you.
Okay, no problem.
And then that's no other questions that I can see.
I'm just going to go, just before you all do just drop off, I'm just going to let you know about some upcoming webinars that we have. So we've got, which is the first one. So this next one on the 1st of October. So this is called Getting a Supportive Workplace Culture, designed to help employees build inclusive, compassionate and high-performing workplace cultures, delivered in partnership with Get Set for Work. So we'll explore simple but powerful ways to support employee well-being, foster inclusion and create a psychologically safe working environment. If you're interested in this one, then do head to our website to sign up for this free webinar. We've also got another one shortly after that, becoming a disability confident employer. So if this is something that you're looking into, this session will guide you through disability confidence scheme, and that will really means to be an inclusive employer. So delivered in partnership with Get Set for Work again, and the webinar explores each level of the government-backed scheme. This one's on the 22nd of October. Again, it's free, so please head to our website to sign up. And just a few final things before you will drop off as well. So if you are considering HR support but not sure if you need it, please do try our free HR benchmark assessment tool. So it works like a HR compliance health check by answering a series of questions via our website. A tailored report will be delivered to your inbox and evaluates 16 key areas. And in addition, we have a sexual harassment risk assessment, another free tool where you can answer a series of questions and receive a report to identify risks and strengthen harassment prevention, designed to help organisations uncover potential vulnerabilities, reduce legal and reputational risks. And it only takes 5 minutes to do as well. And then we also have on our website an employment rights build checklist, which is designed specifically for small business owners to help you navigate these new requirements. And then finally, just before we do finish off as well, I did mention earlier on that we have some additional HR services that we offer. So on, in hand with the HR consultancy side, we also offer things like project management, personality profiling, wellbeing training, EAPs, and it's not listed on here, I've noticed, but we also breed HR partners. So if you're looking for a user-friendly HR management platform to manage all your employee data on place, then get in contact for a free demo. We'd be happy to help you with this. And then just to finish off, if you've got any more questions before we go, and if not, Grace is going to send me the emails for those that have a couple of extra questions, and I'll get back to you after this. But that's all. Thank you very much. It was really lovely to present this webinar. Thank you so much for joining, and thank you, Grace, as well, for making sure it all goes smoothly today. I really appreciate it.